Wednesday will mark the 60th anniversary of the Voting Rights Act of 1965, the landmark legislation securing democratic rights for non-white Americans after nearly 2 centuries of discrimination. In recent decades, the Voting Rights Act has become a shadow of its former self, gutted by the John Roberts Supreme Court with the Shelby County versus Holder decision in 2013, and further chipped away at ever since by Republicans at every level of government. Joining me now is the holder in the Shelby County versus Holder case, former Attorney General under President Barack Obama, Eric Holder. Thank you for being with us today, and we're honored to have you. We want to get into the Voting Rights Act in detail just ahead, but let's start with the breaking news we reported earlier this hour that Democrats in the Texas Assembly intend to break quorum tomorrow in an effort to block a redistricting plan that would give Republicans a chance to pick up 5 seats by breaking up majority Democratic districts in urban areas like Houston and Dallas with large black populations. What are the stakes in Texas right now?
Well, the stakes are enormous. They're trying to do in Texas is to try to manipulate the results of the 2026 election. People should understand that this is not simply a Texas matter. This is a national matter. Donald Trump is telling Texas Republicans to gerrymander even more than they already have to try to find 5 additional seats in an attempt to have a 2026 election that doesn't go against him. He's extremely unpopular now, given the budget bill that they put out that, gave tax breaks to billionaires who didn't need them, took health care away from people who did need it. He's unpopular because of the immigration enforcement methods that they're using, snatching, good people off the streets by the use of masked men. And so they want to try to save 5 House seats that they know they're in danger of losing, and that's why they're engaged in this gerrymander. But people really need to understand something. The focus is Texas. I get that. But this is truly, truly a national issue.
Now, Democratic governors like Gavin Newsom in California and Kathy Hochul in New York are now looking at their own redistricting plans to counter what's happening in Texas. I'd like your thoughts on how effective you think these efforts will be, but I also want to know how this situation has influenced your own position on gerrymandering, because you've been fighting for a long time for fairer electoral maps.
Yeah, I'm the head of the National Democratic Redistricting Committee. We formed up in 2017 to fight gerrymandering. When we started out, Democrats had to overperform by 20%, 22% in order to just reach 50% representation in the United States House of Representatives. We whittled that down to like about 1 or 2% now. And gerrymandering is not a good thing. It is a system where politicians are picking their voters as opposed to citizens choosing who their representatives are going to be. And so I've been against gerrymandering. But in light of what Texas Republicans are doing at the direction of the White House, I say that what we've got to do is take responsive measures that are temporary in nature and combat that. We simply can't lie down and think that if we play fair, we're going to get a fair deal. We've got to do things that maybe I didn't necessarily support before, but that I find necessary to support now. If we want to have a functioning democracy, we've got to make sure that we are fighting them right now as they try to do things that would harm our democracy, potentially destroy our democracy. I mean, what they're trying to do here is an authoritarian measure to try to take away from the people of Texas and from the United States when it comes to the 2026 election that they're trying to manipulate, trying to take away the voice of the people. And so we've got to use all the measures that we can to ensure that we get past this crisis and then get back to the fight for fairness.
Now, there's no question that Democrats should not unilaterally disarm on redistricting when political stakes are so high. But do you worry about a gerrymandering arms race that will only further undermine the democratic system?
Yeah, that really is the danger. I don't want to be engaged in a race to the bottom where you see gerrymanders all over the place. And that really, as I said before, it takes away from the people their ability to decide the direction of the country, the policies that we're going to put in place. And it's why we formed up the National Democratic Redistricting Committee with President Obama, Speaker Pelosi, former Governor Terry McAuliffe, to try to fight gerrymandering. And we've been, wildly successful in doing that. But as I said, as a temporary measure, I think that we've got to use all the things that we can to try to fight that which these authoritarian people in the White House and their lackeys in Texas are trying to do. If we do that, and if we're successful in negotiating this crisis, we can get back to that fight against racial as well as partisan gerrymandering.
Now, let's get back to the Voting Rights Act. We both know the sacrifice and the struggle that it took to pass what is in many ways the crown jewel of civil rights legislation. Without it, everything else is at risk. On Friday, the Supreme Court expanded the scope of a Louisiana redistricting case, asking the lawyers to address whether the state violated the 14th and 15th Amendments in drawing majority black districts to comply with the Voting Rights Act. Can you explain why that request could be a sign this conservative court is about to deal yet another significant setback to the Voting Rights Act? And what is the state of voting rights and the Voting Rights Act at 60 years old this Wednesday?
Yeah, well, the Voting Rights Act was certainly harmed by the 2013 case, the Shelby County case, which took away from the Justice Department its ability to pre-clear electoral changes that were made in covered jurisdictions. Texas, for instance, would not have the ability to do this gerrymandering that they're doing without going to the Justice Department and asking for approval for it, if the Shelby County case had not occurred. Now they're looking at Section 2, which remains an extremely viable part of the Voting Rights Act, and a section that we used to ensure that we got majority-minority districts in Alabama as well as in Louisiana. This court literally 2 years ago said that Section 2 was still viable. Now they're asking a question of litigants from Louisiana about whether or not, in essence, whether or not Section 2 should remain viable. No court, now, people need to understand this, no court has ever held that Section 2 of the Voting Rights Act runs counter to the 14th or 15th Amendment or any constitutional provision. If the Supreme Court were to decide that Section 2, for whatever reason, is violative of the United States Constitution, that would really deal a serious blow to the continued viability of the Voting Rights Act, which, as you say, is the crown jewel of the civil rights movement. And I also note the picture that you had up there, showing when President Johnson was signing that bill. Off to the right, and you can't see her, is my late sister-in-law, Vivian Malone, who integrated the University of Alabama in 1963. And she worked on the voter education project, and that's why she was at that signing. People have been fighting for years simply to be treated equally. And it's why, in the cases that we brought under Section 2, for the first time, black Alabamians had the ability to pick a second black congressman from Alabama.
Well, your sister-in-law, your wife, very much involved in the front lines of the civil rights movement. I want to talk to you about the Trump Justice Department. The current Attorney General, Pam Bondi, FBI Director Kash Patel, and his deputy, Don Bongino, all seem to have been consumed right now in varying degrees by the case of the late sex offender Jeffrey Epstein. His convicted associate, Charlene Maxwell, was moved last week from a prison in Florida to a minimum security facility an ex-prosecutor described on this show just last night as a camp. Bloomberg is reporting the FBI has gone through the so-called Epstein files and redacted references to Trump and other high-profile people, according to 3 people familiar with the matter. Having your name in the files doesn't mean you're guilty or anything, but Eric, you've worked on many high-profile, sensitive cases. What's your reaction to what you're seeing and how it's being conducted?
Well, people need to understand, none of this is normal. I was the Deputy Attorney General, and I can tell you the number of times that I went from Washington, D.C. to a federal penitentiary to talk to a convicted felon, the number of times I did that was zero. If they wanted to talk to Ghislaine Maxwell, you would have sent an FBI agent, potentially a line prosecutor, to gather whatever information is that you wanted to have. The notion that she's being moved from one facility to looks like the lowest rated facility that you can, the one that's the easiest, a camp. Again, given the length of her sentence that she still has to serve, given the nature of her crime, that again is something that is unheard of. So I worry that what is going on here is an attempt to somehow protect the president from, I don't know, his name being revealed in the FBI files and the Justice Department files that relate to Jeffrey Epstein. But all of the stuff that's going on now is simply not normal. And I worry a great deal that we are potentially seeing something, an attempt at some kind of a cover-up. We'll see how this plays out. But certainly, as it is now progressing, it does not give me great faith in the objectivity of what people at the Justice Department are planning to do.
Let me get you to say this again now. You were Assistant Attorney General. I remember that under Janet Reno. We had meetings. And you saying it is unusual unheard of for an Assistant Attorney General to go and interview or talk with a client without a line item, U.S. Attorney to prosecuting attorney. This is unusual.
No, it's not unusual. I think it's probably unprecedented. Todd Blanche is the Deputy Attorney General of the United States. He's the number 2 person in the Justice Department.
And a former attorney a personal attorney to President Trump. But go ahead.
Yeah, and who said during his confirmation hearings when he was asked, would you still have an attorney-client relationship with the president? And he kind of paused for a minute and he said, yes, I would. Now, you got to make a decision. Who do you serve? The people of the United States, or do you serve in the Constitution, or do you serve the president of the United States? The notion that the number 2 person in the Justice Department would go to a federal prison to talk to a convicted felon, and then as a result of that, or at least connected to that in some form or fashion, that person would then be moved to an easier prison facility, is something that is not unusual, Reverend Sharpton. That is something that is unprecedented. I never, ever went to a federal prison to talk to a convicted felon when I was the Deputy Attorney General during the Clinton years.
Now, the administration has tried to distract from the Epstein mess by reviving the Russiagate conspiracy from Trump's first term, even going so far as accusing your old former boss, President Barack Obama, of treason. In fact, the documents they've released related to a report by Special Counsel John Durham John Durham showed the opposite of that, revealing that emails supposedly detailing a Democratic plot were likely Russian fakes. Now, why did they keep pushing this story even when their own evidence contradicts their narrative?
They're doing all of these things now in an attempt to deflect attention from the release of the Epstein files. They accuse Barack Obama of treason. They talk about wanting to rename the Washington football team. They talk about taking Rosie O'Donnell's citizenship away. They want everybody to look over here as opposed to focusing on the issue that really has consumed the American people, Democrats as well as Republicans, conservative as well as progressives, who want to see these files to get a sense of what's in there, who was involved. And again, just because your name is there doesn't mean that you necessarily did anything inappropriate. But I think that it is time for those investigative files to be shared with the American people. Now, you need to respect the privacy of people whose names appear there, especially the names of victims. But there's a way in which you can produce this information so that everybody has the opportunity to look at these Epstein files that they were extremely interested in when they were not in government, but now that they are, the Attorney General, the head of the FBI, seem not to have the same fervor, the same desire to see these files released.
Finally, I would be remiss if I didn't ask you about the Justice Department Civil Rights Division under Trump, which has been turned on its head under the leadership of MAGA activist Harmeet Dillon. 70% of the division's lawyers have left since Trump returned, as the focus has shifted, rooting out so-called anti-white and anti-Christian bias. What are we losing as this institution is gutted before our very eyes?
The Civil Rights Division is the crown jewel of the United States Department of Justice. It protects the rights of all Americans when it comes to education, when it comes to interacting with law enforcement, when it comes to job discrimination. And the notion that you would take steps that would force, as you said, 70% of the people in the department, in the Civil Rights Division, to leave, really creates a vacuum and allows for people who are zealots, who are crackpots, to come in with theories about reverse discrimination and a whole range of other things that puts the Justice Department, the Civil Rights Division as it exists now, in a position that's completely opposite to the way in which the Civil Rights Division has been operated under both Republican as well as Democratic presidents, as well as Republican and Democratic attorneys general. And I'm very concerned about the fate of the Civil Rights Division and the fate of the enforcement of civil rights statutes. When you've got, as I said, somebody who's a zealot running the Civil Rights Division, we can only hope that as many people stay and do the job as best as they can, and to try to counteract these anti-civil rights views that this Assistant Attorney General actually has.
Well, thank you for being with us on this week. We mark the 60th anniversary of the Voting Rights Act. Former Attorney General Eric Holder, thank you for being with us again.